To order. Sergeant Arms, please secure the doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President.
All right. This morning, we are very pleased to have the Father Paul Sparklin of the St. Elizabeth Ann Seton Catholic Church in Crofton, Maryland, guest of the distinguished senator from District 33. Members, please rise for the invocation.
Let us settle our hearts for just a moment in prayer. God of justice and mercy, thank you for the gift of life and the opportunity to serve the people of our state. Help us to act with character and conviction. Help us to listen with understanding and goodwill. Help us to speak with charity and restraint. Give us a spirit of service. Remind us that we are stewards of your authority. Guide us to be the leaders your people need, especially during this time of pandemic. Help us to see the humanity and dignity of those who disagree with us, and to treat all persons, no matter how weak or poor, with the reverence your creation deserves. And finally, O God, renew us with the strength of your presence and the joy of helping to build a community worthy of the human person. We ask this as your sons and daughters, confident in your goodness and love. Amen.
Chair recognizes the senator from the 33rd District.
Thank you, Mr. President. Move that we journalize the prayer.
Without objection, we will certainly journalize the Father's invocation this morning. All right, has everyone recorded their presence? If so, the clerk will take the call. With 46 members in the chamber and a quorum being present, the Senate of Maryland is now in session. Announcements. Protocol, doing our pages for the week? Do we want to... Any mention of the pages today? Yes, Chair recognizes the Protocol Committee.
Thank you very much. Yes, ladies and gentlemen, we will have pages this week. They took a break last week. That's why you didn't see or hear from them. But you will have a list on your desk, and on Friday, we will bid them adieu, because this is the second week of their 2-week cycle. So we welcome all of the pages. Thank you for joining us. We hope that you have opportunity to connect with your legislators, ladies and gentlemen. And we know that you are the brightest and the best, and you're here with us virtually. So thank you so much for joining us. Let's give those pages a round of applause this morning. Thank you.
We welcome our virtual pages, our all-stars who will be introducing at the end. We just are so thankful for them, despite them not being able to be here physically with us. Other announcements. Yes, Chair recognizes the President Pro Tem.
Thank you, Mr. President. Just a personal announcement, if I could.
Senator may proceed.
Thank you, sir. I had the honor last month standing at the beginning of the month, acknowledging Black History Month, as we heard how Senate Bill 1 and passed the HBCU bill. It is now the beginning of Women's History Month 2021, and we have a woman in our chamber, Mr. President. Permission to use the senator's name?
Senator may proceed.
Oh, okay. Senator Kathy KLAUSMEIER started among the women of the Senate a unique identifier for us. And so you'll see, Mr. President, the mask that I'm wearing in honor of Senator Kathy KLAUSMEIER. All the women have them, and by the end of the month, we hope to have them for the men as well. Thank you, Mr. President.
Wonderful. Thank you. Thank you for that observation. We thank the senator from the 8th District for not only her style choices, but her leadership as well. And actually, hopefully the senator got the text message I sent. I had a memory pop up in my Facebook that was a picture of the senator carrying the women's right it was from yesterday, so it was 7 years ago yesterday where we had a procession into the Senate with the right to vote placard. So it was a great event, and hopefully the senator got my memory picture.
Besides handing out a mask, I mean, I hope I'm remembered for as much of that. That's fun part about our family here in the Senate. But I do want to say that, yes, 7 years ago we did do that, and unfortunately last year for the 100th anniversary we weren't able to do anything. But I would like very much so to get the commission members on the video and have a resolution made out to them, because it was so just disappointing to many of us in this room, actually, that we did not do the big celebration that we really wanted to. So,
absolutely, we'll follow up with that after session about making sure we can schedule that, without a doubt. Very critical. All right, any other announcements? Everyone have their phones silenced. Before we jump into things, I just want to make a quick note of personal privilege here. So today we're going into some issues that are very emotional and tough, and so these are very deeply held, important issues that have a lot of really intense emotions in many different ways. And what we will have is a very spirited debate, I would imagine, on a number of different fronts. Unfortunately, over the last couple of weeks, the tone and tenor of how our words are heard, our actions are seen, has led to individuals to making what I would call pretty unacceptable choices. And I think the best example was an email that we received, the speaker and I received this week, both from somebody outside of our own districts, that said, "I sent you an email regarding key thoughts and recommendations on key issues that is being addressed in this legislative session. I never so much as gotten an acknowledgement or thanks for my input. So since you do not answer me, I guess I will just share my concerns and recommendations with some of your family members in hopes that they can relay them to you." This is partnered with some activities of different groups from various perspectives choosing to go to members' homes and protest in front of homes. I just want to make a very clear statement that we can disagree, but the fundamental principle of democracy is that we disagree in an agreeable way and we hash out our differences. We don't threaten and intimidate, particularly members' families. This is a red line. All of us got into this work. We know that we're going to get some tough criticism. We're going to get yelled at times. That's part of the job description. But our families don't sign up for that. And I just want to be very, very, very clear that our words and actions are watched, but it is totally unacceptable for the use of family or violating somebody's privacy, family member's privacy, in an objective to accomplish some sort of legislative goal. And whatever the perspective may be, whatever side or political part of the spectrum somebody may be coming from, family is off limits. And so I just want to say that as we go into this debate, because I think what we will do today is model the best of democracy. We will disagree on issues. We will have a hard debate. We will have a battle of ideas, and then we'll get to a conclusion. That's how we move forward as a society. The politics of intimidation, particularly of people that don't sign up for it, is just never acceptable. And so I don't mean to start on a negative note, but I think it's important to make that point known, and that we are watching very, very carefully for anything like that. All right. Any other announcements before we jump in today? All right. So be considered the reading of the journal from the prior legislative day. We have some introduction. Reminder, Monday, March 8th is the last day to introduce a bill without suspending the rules. Monday, March 8th. So that will be next Monday. That's also the last day for LBIs. But let's get we have some Senate bills. This is calendar number 30. Clerk will read the first bill.
Senate Bill 949, Senator Hershey, Public Utility Bills for Electricity Service Meter Reading. Senate Bill 950, Wicomico County Senators, Wicomico County Alcoholic Beverages, Class A Beer, Wine, and Liquor Licenses, hours.
Majority Leader moves so be considered the reading of the bills. Next we have some bond initiatives. This is calendar 22. Clerk will read the bond initiatives.
Senator Hayes, Hamden Family Center.
Majority Leader moves so be considered the reading of the bond initiatives. We have some House bills that have been sent over to us. This is calendar number 7. Clerk will read the House bills.
House Bill 126, Delegate Moon, Public Safety Pretrial Services Program Grant Fund, Extension and Program Requirements. House Bill 135, Delegate Young, Pharmacist, Administration of Self-Administered Medications and Maintenance, Injectable Medications, Christopher King, Access to Treatment Act. House Bill.
Majority Leader moves so be considered the reading of the House bills. All right, Senators, the next calendar is the laid-over calendar, and I forgot that I didn't talk about our schedule today. So we're starting with the laid-over bills. We'll get through the laid-over bills. We'll see where we are. We will have today's session. If we need it, we will have an evening session this evening at 6. We will have the same plan for tomorrow. We'll see where we are. If we don't need it, we don't need it, but we have it scheduled in case we do. And then we will have Thursday at 10:30, Friday at noon. And again, the 10:30s are tomorrow and Thursday. That's so that we have a half-hour delay. The House is starting at 10, so we want to stagger our entrance and exits. All right, so let's go to the laid-over calendar. This is calendar number 8. We'll go to the first bill. Clerk will read the bill.
Senate Bill 71, Senator SYDNOR, Police Officers' Testimony, Presumption of Inadmissibility, Maryland Police Accountability Act of 2021.
All right, Senators, the question is on the adoption of the two committee amendments. Any discussion on the amendments? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The two committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 71 is hereby ordered printed for third reader. Clerk will read the next bill.
Senate Bill 74, Senator Washington, Police Officers, Mental Health, Employee Assistance Programs.
All right, questions on the two committee amendments? Any discussion on the amendments? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The two committee amendments are adopted. Question now is on the favorable committee report as amended. Any discussion? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 74 is hereby ordered printed for third reader. Clerk, read the next bill.
Senate Bill 178, Senator Carter, Public Information Act, Personnel Records, Investigation of Law Enforcement Officers, Anton's Law.
Give us just one moment. It looks like we have the... All right. Question is on the two committee amendments. Senate Bill 178. Let's make sure that we're right on the calendar, on the journal. We're good? All right. We just want to make sure that we get it right. We know that with our remote viewing, we want to have it all accurately there. All right, we have the two committee amendments. Is that correct? Two committee amendments. Questions on the two amendments? Any discussion of the amendments? If not, all in favor of the amendment say aye. Opposed, nay. The ayes have it. The two committee amendments are adopted. Question now is on the favorable committee report as amended. Yes, Chair recognizes Senator from Prince George's.
Yes. Could the maker of this
The floor leader?
bill please stand?
The floor leader, Senator?
Yes.
Appears so. Senator may proceed.
What I want, before we adopt the favorable report as amended, I would like for the wonderful sponsor of this bill to explain to us what does this bill do as it is amended.
Thank you, Mr. President. And in response to the senator's question, the bill removes the police disciplinary records from the prohibition under the state personnel records, and makes them now permissible under certain specific circumstances as specified under the bill. So there are 7 criteria that a custodian of records must meet in making a determination whether a record would be disclosable or not. In a broader answer to your question, it removes a veil of secrecy that police disciplinary records have been shrouded in for a long time. All of the data that we have indicates that about 92% of these records are unsustained. Allegations are unsustained. And so it would allow for the disclosure under certain circumstances of sustained and unsustained records.
Further questions, Senator?
Yeah, thank you for that. The question I want to ask of you is, when a complaint is determined to be unfounded, it means the allegations carried no foundation or basis in fact. When a complaint is not sustained, it means there was insufficient evidence to prove or disapprove the allegation. When an officer is exonerated, it means the officer's actions were in compliance with department policy. Do these amendments that have been added to this bill protect? Let me say from the onset, you all know that I don't do a lot of standing around here. I don't stand up a lot. You all know that, don't you? Now listen, I'm here standing because I want to protect those officers from the state police and other officers that I'm working hard with. And I want to be sure that they're taken care of. Now here's the story. If an officer, if a complaint is filed against an officer, and the complaint is found, there's no merit to it, is that officer protected? Because what they're saying to me is this complaint, their complaint is put on their record, and the complaint stays. And it gets in the way of these officers who are seeking promotion. One officer said to me last night that the complaint that was lodged against him happened 18 years ago, and that is blocking him from getting promotions. Now, I'm just wondering if these officers are protected, and I want to be clear that I'm out to protect the interests of the African American police officers who are with the state police. Because I'm telling you, ladies and gentlemen, if you saw what I've seen and what the Black Caucus have seen, I don't have to tell you, Senator, it's despicable. And I'm out to ensure that they are protected. Because this gets in the way of them getting promotions, and when they leave, it stands in their way because they pull their records and find these things are occurring. Now, you all are saying to me that it's taken off their records after 3 years. I want to be sure that that's in fact included in these amendments.
So, Madam Senator, this bill, neither the bill nor the amendments would impact whether or not a complaint, whether it's sustained or unsustained, unfounded, founded, exonerated or not. Nothing in this bill or the amendments would impact that. The record is the record, and under current law, an officer has the ability to expunge from his or her record, from their record, an unsubstantiated complaint. This doesn't affect that at all. This bill that speaks to whether or not a record could be disclosed. If it's not there, it can't be disclosed. But in the case that you mentioned, where someone has a complaint for 18 years old, if it was unsustained, they have the ability under current law to expunge that from the record. So this bill doesn't affect whether something stays on the record or not. It only affects it if something is on the record, that there are certain circumstances where it may be disclosed.
So if there's not enough evidence to imply or to show that an officer is guilty of a complaint that was lodged against them, nothing happens. It doesn't go on the record. Is that what I hear you saying?
We'll be in, so right now, regardless of this bill, the complaint will be in the record, the determination will be in the record, and none of that is disclosable to the public under current law. Under this bill, if there is a request for disclosure, whether it be from a person who actually filed the complaint or a member of the public, a party in interest is how the bill is written, then it is possible that it could be disclosed. But most likely, it wouldn't be the old complaints, because under current law, they have an ability to expunge records after 3 years.
So the concern that I have is not a part of this bill.
It is not.
Which bill is it a part of, my dear? Because I'm telling you all, that's a problem.
So I'm not really sure, because none of our bills prohibit an officer from clearing their record. In fact, one of our other bills that will come up continues to allow them to clear their record of an unsustained complaint. Okay, sustained complaints stay on the record. I don't know that there's a process to remove that from the record. But unsustained complaints now are able to be removed from the record after 3 years.
When I talked to the officers yesterday, it was a very diverse group of officers. They were not just African Americans. And this Senate Bill 178 was a great concern for them relative to what I have just stated. And that is a concern. So I'm just wondering, do these amendments help with that? That you say it does not.
No, so all these amendments do is, one of them, one is technical, the other one simply ensures that if there is a technical infraction, a very minor infraction, violation of an agency's rules, it wouldn't fall into the category of potentially disclosable records, because it's not actually something that a member of the public has complained about regarding the officer's public performance of his or her duties.
Okay.
So should I clarify just exactly what this bill does? So this bill, with amendments, allows for it makes it permissible that disciplinary records can be disclosed whether the complaints have been sustained or not sustained under certain circumstances. Now, there are protections in the bill so that everything isn't just automatically disclosed. There are certain protections. There's 7 kind of caveats that would not allow for the disclosure of those records, and those are, for example, if disclosure would interfere with a valid and proper law enforcement proceeding, if it would deprive another person of a right to a fair trial or an impartial adjudication, if it would constitute an unwarranted invasion of privacy, if it would disclose the identity of a confidential source, disclose an investigative technique or procedure, prejudice an investigation, endanger the life or physical safety of an individual.
Okay. I just want you to know, wonderful Senator, that this is one of the biggest complaints of those police officers. They were very concerned about Senate Bill 178, but the way that you were explaining it indicates that what they're concerned about is not necessarily included in this bill. Is that correct?
Correct.
Well, okay. All righty. Okay, thank you. You're a wonderful person.
All right. Senator from the 32nd District, is this on the report?
I have some questions of the floor leader, Mr. President.
Senator may proceed.
Thank you. Thank you, Madam Floor Leader. So I just want to understand the premise of Senate Bill 178, and it got a little more clear with your discussion with our lovely senator from Prince George's. So if an officer is wrongly accused and there's no evidence to support his claim of misconduct, the false claim can be part of his public record for 3 years until he is asked for it to be exonerated. Is that correct?
Well, it's part of his, right now, under current law, it's part of his disciplinary file within the agency. Under this bill, that would be potentially disclosable if it meets the criteria.
So someone who's found, you know, as I said, either the evidence doesn't support the claim, or he's investigated and the claim is said not to be, not to be found guilty, it still goes on the record that's accessible to the public for 3 years.
It could, assuming there's a request to have it publicly disclosed and it meets all the other criteria, yes.
And so let's just do a little scenario, okay? So a police officer stops a young lady speeding, and it's like her third speeding ticket, and she knows she's probably going to lose her license. So she claims that he sexually harasses her so she can get out of this speeding ticket. Turns out, like a good officer, he has his body camera on, and it's clear that he never sexually harassed her. But that could go on his record as a possible sexual harassment and stay for 3 years.
Well, it will go in his file now as an allegation. And if the agency does not find that it doesn't sustain it, then it's possibly able to be scrubbed. Now, under this bill, if there's a request for disclosure, whether it's from that person that made the complaint or another member of the public, then yes, that's disclosable. But I want to say that I think the good news is that all of that information, what went into that investigation, is disclosable. So it's not just a matter of, there was this, inflammatory allegation, but actually a person would be able to ascertain, well, the agency did a thorough job in investigating that complaint. The agency, did proper interview, conduct proper interviews, reviewed the body cameras, did all of the proper things, and after all of that concluded that this was completely frivolous, as opposed to now where, a complainant or a member of the public is not able to know anything that happened in the realm of that investigation and just left to totally guess why the agency came up with the decision that it did.
So the public information request could yield the potential but not found guilty claim, and not necessarily that person that's asked for the public information reads all of the testimony and everything that happened, but they read that this officer was charged with sexual assault.
Well, they'd read whatever information is disclosed out of the file, yes.
If they read it all. So if a law enforcement officer is accused and the claim's investigated by Internal Affairs or Civilian Review Board or the chief, and the investigation exonerates the officer, that claim still becomes part of the public record that can be achieved by a PIA request, even after exonerated.
It could.
So why should we have unsubstantiated claims be part of a record that can be attained by the MPIA?
Well, because it's critically important if we're going to find out not just about individual officers, but to find out how the agencies are investigating these complaints, to make sure it's really also a check on the agencies. Because what all of the data reveals is that all across the state, agencies have failed to properly investigate allegations. And so, for example, a recent report that came out shortly in January revealed, for example, in Baltimore City, there was one officer that had 66 unsubstantiated complaints, was still working. And another example that came up at the bill hearing that I thought was rather compelling was in January of 2020, William Green was handcuffed and shot to death in Prince George's County while he was in a patrol car by an officer. And it was revealed that a few years before, a woman during a routine arrest had been choked by him to the point, while she was in the patrol car in handcuffs, she had been choked to the point where she had urinated on herself. The agency had looked at the complaint and said, oh, we don't have enough here to find that anything was done wrong, so it was not sustained. The only way we can be sure that agencies are properly investigating these complaints, taking them seriously, is if we have access to the records. Like right now, even if you or I filed a complaint against an officer, we have no ability to know what happens except they can tell us at the end we sustained it or we didn't sustain it. But if it's not sustained, and like if it is a real allegation of sexual abuse, something that really happened, a horrific allegation of sexual abuse, and it is not frivolous, and they don't sustain it, which it shows 92% of time in all allegations they are not sustained, we don't have any ability to know what happened. Did you really investigate? Did you really interview witnesses? Did you look at all the body camera footage? Was any body camera footage missing? You know, all of those things we can't find out. Nobody can find out, and that's the harm that we have with the current law and why we need to change the law.
Well, it appears that the changes in the LEOBR are going to change a lot of that investigation with civilian review boards, and I think that's going to make it much more transparent. So, you know, as senators and delegates, if we have someone file a complaint against us, it quietly goes to the Ethics Commission. And none of it's talked about. It shouldn't be. It should never be mentioned unless that person is actually found guilty of an ethics violation. Other than that, it just quietly goes away and we never know. And that's how it should be, I think, when we're not guilty. But in this case, you're not guilty, and it's still out there for public information. And I just have real concerns about officers' careers and families being affected by false allegations. You know, in New York, when 50A was appealed, the ACLU obtained records on every police officer, sustained and unstained, and made those public records. Is that what we're going to deal with if this bill is passed without an amendment?
So I can't speculate on the future hypothetical of what could happen, but I will say that another thing that's significant that happened in New York after 50A was repealed is that it was revealed in news media that agencies were feverishly working to rip apart, to tear up, eliminate their records so that they couldn't be disclosed because they wanted to keep them sealed and never reveal it to the public. So that was something. And then also the FOP went to the court to try to get this repeal of 50A determined unconstitutional, but the court upheld it and said, no, these files should be public. These are public servants. These are public records, and they should be disclosable to the public. And so not only New York, but it's my understanding that there are about 14, that we would be joining 14 states that make these records totally disclosable. No, we aren't making them totally disclosable. We're saying, hey, you got to look at this criteria, and if it meets it, it can be disclosable. Another overwhelming majority of states has some permissible disclosures with checks and balances, as we will. And then there's only a few states, a minority, I'm not sure the number, but I have in my notes, how many say no disclosure at all. And so I think that the old ways of keeping these records secret has not served us. And so while there are some valid points to possibly potential harm to reputation, I think that in balance, the harm that is caused by keeping them veiled in secrecy far outweighs that. And the other issue that you mentioned was brought up in committee, the idea that we are also public servants and we should have our ethics allegations disclosed. But I would just say that, as I said in committee, that I think that's a different bill. We had hearings on this bill. We had hearings where people came before us and talked about how they were unable to get access to these records. We had hearings where we learned that there were officers with multiple offenses, some with 15 allegations unsustained, still working on the force. The gun trace task force, 3 of the officers had 40-some unsustained complaints prior to when they got indicted in, I think it was 2017. And so we heard evidence for this. On the other issue, it's my understanding that in 2018, there was a House bill that would have dealt with the issue of disclosure of our public records, and it was ruled unfavorable. It was deemed unfavorable by the House Government Operations Committee. And so I just think that's a different bill that should be vetted in a different way.
Well, Senator, thank you for those comments, and I'm not asking that be included in this bill. I'm certainly not. I'm just trying to relate the fact that all of us as individuals, when someone makes a claim against us that's not founded, it's not truly honest, it very much affects us and can affect our reputation. And I'm just trying to protect the reputation of our good police officers, our public servants that are hurt by having possible frivolous complaints become part of their personnel record. I wonder if you all didn't have a chance to see, we've received a letter from the Maryland Chiefs of Police asking that we not allow this bill to go without an amendment. So we've given the police chiefs a lot of authority in the changes in the LEOBR, and they're asking us to change this bill because they don't feel like it should go like this without an amendment. And so, Mr. President, I do have an amendment I'd like to offer.
Senator, we are still on the amended report.
Okay.
Let's make sure that we accept the report before, or we'll take up the amendment after the report.
Thank you.
If there's any senators who have would like to further discussion on the report before we adopt the chair recognizes the senator from District 10.
Thank you. Madam Floor Leader, going back to questions raised by the prior speaker, would you say that when some member of the public who has had an interchange with the police makes a record, an allegation, that the two don't have the same level of power in whatever happened initially, the thing that is being complained about, and only one of them is subject to public scrutiny and, if found guilty, to public response? Is that the case?
I'd say that's fair. I think that it has been our great understanding and reverence for the incredible work that law enforcement officers do, why we have been very hesitant in the past to move in this direction, to allow for these kinds of disclosures to be made available to the public. This has come on my radar ever since, I think it was 2010 or 2011 with the DeShields case, where a complainant who had received, once again, Prince George's County, Ms. DeShields had complained against officers in Prince George's County for making racist comments and among other things, and she was unable to find out what was the outcome. Was there any finding? Was there any determination? Was there any discipline if there was? And the Court of Appeals said under our current law we can't allow for even the complainant herself to find that out. So,
well, let me ask you this. Even when the ultimate outcome of the complaint is that it's left unfounded after there's been an investigation, it doesn't necessarily mean that anybody lied, does it?
No.
Members of the public are not, in most cases, trained to understand the nuances of the law. They don't know much about the law. They don't know when aspects of their encounter with the police were permissible in terms of the police action or unpermissible. Isn't that the case?
That's correct.
Usually? So the fact that something turns out to be unfounded is an important thing in our law and in our government, that sometimes the person who makes the complaint is totally serious, is an honest person, but simply doesn't understand the law and how it applies to the case. Is that?
That's correct.
Okay. So you can make a complaint after there is an investigation, there's a finding of nothing really there from a legal perspective, but it doesn't mean that you did anything wrong. A police officer should be aware that many members of the public simply don't know when the police are acting within the bounds of the law and when they are not. Is that the case?
Yes, that's correct.
If you were a member of the public who never had any former interaction with the police regarding your own behavior or your own presence somewhere or your ability to do or not to do something that the police officer is impacting, in most cases, just as a member of the public, you don't really know if the police is correct, and you probably, if this is your only encounter, in a state of high emotions. And if you have felt in previous encounters, or you have actually in previous encounters seen in your community disparate behavior on the part of police when they're dealing with different demographics, you might think, wrongly or rightly, that in your instance, the police is doing something that you ought to report, that it's something against the law, when it may be or it may not be. Is that the case?
Yes, that's correct.
So it's important that we have investigations of the complaints and that there be a finding by people who do know, who are responsible for making the finding and who understand the law and how it applies in the particular case. Wouldn't that be the?
Yes.
Okay. And a police officer ought not be surprised if occasionally somebody who reports them as with some kind of an allegation or misconduct is wrong simply because they're ignorant. They are simply an untrained in the law member of the public, impacted in a way that they feel is wrong, and they made a report. Wouldn't that be the case? That's going to happen sometimes, wouldn't it?
Yes.
Okay. So not having, and so it's important that if what you're saying can, after 3 years, become public, is made public, in a case where there's a finding that there was nothing there, that's important. Because in many cases, other citizens or residents or bystanders who observed the original thing might otherwise, if you don't get the finding on the record, think forever that all police are terrible and that in that case the police was wrong, when in fact the police was right or within the boundaries of the regulations and the law. Wouldn't you say?
Yes.
So there is value to all of us that police officer's name could in a way be cleared if that is what ought to happen.
Yes. I think the transparency is of value to everyone, the police, the public, and the agencies, yes.
Oh, thank you.
Thank you.
All right, question is on the favorable committee report as amended. Any further discussion? Yes, Chair recognizes the senator from Prince George's County. It looks like a question.
I'm just curious here for a moment. For the complaints, what percentage of those complaints are internal as opposed to public? Do you have that information? Because what we were told,
we saw some data.
I was told, is that a lot of the complaints against the police officers, particularly police officers of color, the complaints are internal. Could you tell me the percentage of complaints that are internal as opposed to not being internal?
So I can generally tell you, I know that we had some data on the difference between internal and external complaints, and I can tell you that internal complaints make up a much smaller percentage than complaints from the public. Internal complaints, the rate of sustaining those complaints is at a higher rate, percentage-wise, than sustaining complaints from outside, from members of the public. But of course, every agency is different. So, you know, it could be like, I think I recall 22% of complaints in Baltimore Police Department in the last report were internal complaints, and they were sustained at a higher rate than all of the other complaints from the public. But it will be different depending on every agency is different.
Thank you.
All right, questions on the report? Any further discussion? Yes, Chair recognizes the senator from Baltimore City and Baltimore County.
Thank you. Question for the floor leader.
Senator may proceed.
Thank you. Just so that I'm clear, because I think there's a lot of misperception out there, does this bill open up the floodgate for everyone to see everything that's happening in the police department?
No, this bill does not automatically just disclose every single complaint that's been made, whether sustained or unsustained. There's a process in the bill where a party would make a request, and a custodian of records would now say, well, rather than say this is 100% prohibited, well, it's permissible, but as long as it doesn't do certain things like interfere with an open investigation or something like that, the other six factors, then they can now disclose it. So it's not a database, it's not, a report, it's just, an individual case-by-case basis that'll be determined.
And the information that comes out, let's say for one of these unsustained complaints, all of the information would then be provided to the public if it goes through this process, and if the custodian of record allows it to come out. The general public would then see it and would be able to actually see the facts as to why it was adjudicated as unsustained, right?
Yes. So I think that's important, because it's then, if it were you or I, we'd be able to say, hey, yeah, this complaint was made or these allegations were made, but they were unsustained. And look, the reason is they were deemed frivolous. There was no evidence backing them up, or the evidence, the cameras, the witnesses, all of the physical evidence, all the circumstantial evidence, all pointed in a direction that negated the allegations made. Thus, I was exonerated with good reason.
Got you. Senator, you've been a representative for the city of Baltimore for how many years?
Many years. I've been in the Senate for 3 years. I was in the House of Delegates for 14 years.
And during that time that you've been in office, do you remember a Department of Justice investigative report being put out about this topic?
Yes.
Within that particular report, I believe it says that of the 1,382 allegations of excessive force that BPD tracked from 2010 through 2015, only 31 allegations, or 2.2, were sustained. These allegations arose out of 14 separate incidents. BPD completed investigations into 1,359 allegations of discourtesy from 2010 through 2015 and sustained just 2.6% of those allegations arising out of just 15 incidents. Have you ever been stopped by the police?
Have I ever been stopped by the police? Yes.
Were they discourteous to you in any of those?
So it's been a while, I'm happy to say, but when I was younger, it happened quite a bit. And most of the time, they were courteous. I'd say 2 times that I can recall they were not courteous.
Do you think that their discourtesy might be considered frivolous to some officers?
Well, absolutely. It's certainly subject to interpretation. And what we found is that the very nature of the internal process of policing themselves, investigating themselves, has yielded to the benefit of, or to the findings of unfounded and unsubstantiated.
Thank you.
Thank you.
All right, question is on the report. Any further discussion before we take on the report? If not, let's see where we are. We'll do questions on the Favorable Committee report as amended. All in favor of the report say aye. Aye. Opposed, nay. The ayes have it. The Favorable Committee report as amended is adopted. All right, are there any amendments? The chair recognizes the senator from the 32nd District has an amendment.
Thank you, Mr. President. The amendment number is 663-225/1.
Senator, just give us one moment. 663.
225/1.
225. One moment. 225/1. Do we have it? All right, it is there. Senator may explain the amendment.
Thank you very much, Mr. President. So what this amendment does is it really removes the unsustained charges when when there is not clear and convincing evidence that an infraction occurred, or that there's insufficient evidence to prove that an infraction did occur. It also says that basically that this is to be going forward, it's prospective, not retroactive. The amendment really is an attempt to try to apply the chief's letter that we received, that they want allegations that did not occur or unfounded, that if it did not occur, there was no wrongdoing, they were exonerated. Evidence does not occur, does not indicate that there's any wrongdoing, non or not sustained, or the evidence indicates that an allegation occurred, sustained. So releasing information with any other finding except sustained could damage an officer's career and reputation. So this is an amendment to try to address the sustained and unsustained. I also want to go back to this issue of, someone can be exonerated, can expunge their record after 3 years. You don't expunge what goes out on the internet. You don't expunge what goes on Facebook. You don't expunge what you can Google about a person. And so once we've allowed unsustained complaints to go against an officer, it's going to be with them for life, whether or not they expunge in 3 years. So I ask for a favorable report on this amendment. Thank you.
Senators move the amendment. Chair recognizes the floor leader.
Thank you, Mr. President. I would ask the body to resist this amendment. I fully understand the concern of someone being falsely accused and it being disclosed. But again, on balance, the chiefs and sheriffs that want this, it is the very chiefs and sheriffs that actually need to be held to this level of transparency and accountability, because it is the agencies that have failed time and time again to properly investigate and sustain complaints that need to be sustained. In one of the reports that I read, there was a refusal to sustain complaints in 4 instances where officers were criminally convicted of the very same things, but yet the agency still unsustained the complaints. So we will never be able to move to where we need to move in the state of Maryland to build and restore public trust in law enforcement, which is critical if we're going to improve public safety. We have to restore public trust. And one of the best ways we can do that is to show the public that we are willing to have transparency about these complaints within the agencies. And I do understand, I don't want to compare apples to oranges, but if any one of us were to walk out of here today and have a false allegation made against us, which happens to everyday people all the time, it will be right there on case search. Anybody could look it up. It isn't proven. There's been no determination that it happened. It's out there for the whole world to see until such time as we're able to get into court and show that we can either get it, get a finding of not guilty or some other good finding, assuming that it isn't true. So it is true that there are times when an allegation is made that is not sustained and it is put into the public. But the greatness of our system is that we do allow for something to be determined guilty, not guilty, sustained, unsustained. And then from that, people are able to show what really happened. And so what this does is it says, we're not just going to rely on the unsustained. We're going to look and say, hey, they really did a great job investigating this. They did what they were supposed to do, and we can stand by the integrity of this investigation. We can stand by the integrity of these law enforcement agencies, and what's most important is that we can stand by the integrity of our law enforcement officers, and that is what all of this is designed to do. I want to say also that in the states that have done this, there's been no parade of horribles, harms to officers, been no reports of that. That hasn't been a problem. That's not really a thing. It's something I understand we're concerned about, but it doesn't outweigh the benefits of having this level of transparency. So I would ask the body for those reasons to resist this amendment.
Thank you, Senator. Our chair recognizes the senator from the 34th District. Suspect there may be a number of senators who wish to speak. Just a reminder, please hit the speak next button it is very difficult to see. So we'll do the 34th district, and we're going to go in order. Remember, every senator has the opportunity to be heard once before all other senators are heard, and then we'll go back after all senators who have not yet been heard have the opportunity to speak. Chair recognizes the senator from 34th district on the amendment.
Thank you, Mr. President. Colleagues, I rise in support of the senator's amendment. I guess the first question we have to ask in all this is, why do we have the current system? Why are public records of these investigations? Why are these not made public as a matter of course? What's the rationale in that? And the rationale is, I guess to give you an example, if the president of the Senate asked one of you to investigate an allegation against one of our colleagues, something inappropriate, sexual harassment or something, and he said to you, I want you to investigate it thoroughly, but then just come to my office and give me the results so then I can take action. But I need you to do it thoroughly. Okay, that's the first example. The second example is, I want you to go investigate it thoroughly, and I want you to take your results and give them to the editors of the Baltimore Sun. So you've got two possibilities here. In the first, where you're going back to the President of the Senate, you're going to feel very confident in going around to the people you're talking to and say, listen, I'm conducting a confidential investigation. There's an allegation that Senator X engaged in this inappropriate conduct, and we're really got to just do the right thing here. And don't worry, your name's not going in the public because you can speak in confidence to me. And what we're going to ultimately do, we're going to give this to the president, and he's going to try to just do the right thing. And we've elected him as our leader, and that's the right thing to do. In the second case, you're going around saying everything's going to be public. Come on, there's a chilling effect. There's an incredible chilling effect on that investigation. And that's the reason that we don't make these all public. As a matter of course, we don't do that in any public employees. So the rationale, the logic is there. It's undeniable. The issue is, well, we were told that, well, you know what? The police are different. They have a lot of power. Well, I don't dispute that police have a lot of power. They carry guns. But does a police, and when a policeman messes up, it tends to be, more glitzy. But really, do we really think that teachers don't have power? Teachers mess up, a police officer messes up one big way, and boom, all the attention comes. A bad teacher messes up every day with 30 little lives for year after year and degrades their education, degrades their self-worth, degrades their income, degrades everything. Isn't that power? Seems to me that's a heck of a lot of power. So the issue really isn't one of power. It's not really fair. How about state senators, state delegates? Our misdeeds, we're here passing laws that affect every citizen in the state of Maryland. Isn't that a substantial amount of power? Doesn't this logic apply to us as well? That we have a lot of power, and therefore all investigations by our ethics committee ought to be, hey, when you're going around, you just say, hey, bud, this is going out. It's going to the president, but immediately he's going to put it down. It's going to go right out to the Baltimore Sun because it's important to have transparency. And the only way to do this right is to have total transparency. Really? Look, we were told that there's massive failures of the current system, and we were given an example. We were told that hey, there was a case with horrible sexual abuse. Okay, we need to figure out, just please give me your attention for a second on this, because you need to understand exactly what we're talking about here. These are administrative investigations. This is not the criminal investigation. Officer Jones messes up. He can be, state's attorney can come in, the local police, the FBI, whatever, nails his butt or her butt, and they're criminally prosecuted. This law has nothing to do with that. The next thing down is somebody can file a civil suit. Officer X touches you, that's a civil assault, that's a sexual assault, you can both do criminal and civil. This stuff is totally irrelevant to that. You can go after Officer X for that. This is the next level down. This is the administrative. This is the administrative agency to say, all right, we don't have power to prosecute. We don't have power to sue him. What we do have power in this administrative level is to say you can't get promoted, or you're demoted, or you're going to be sanctioned, dock some pay, or you're going to be fired. That's what these guys have. All those things much more can be done at the other two levels. So the reason that we keep these confidential is we want open, thorough investigations, really digging into all the facts so that we can make sure that we get rid of bad cops, right? That's the purpose of this. Then one challenge we've had is that even once you identify that problem officer, that we had challenges with the hearing boards. That's another bill. So please don't confuse the issues here, because this bill does not stand alone. There's a lot. We have 8 bills here to go through that all are intended in some fashion to address the very issues that the sponsor is trying to address with this bill, right? They all go towards that integrity piece. So we have to say, do we need to just throw the police officers' records into the public? Is that really the only solution? That's really what we're being told by the sponsor on this, is just look at this in isolation. I ask you not to look at it in isolation. This is a package. So do we need to go to that, and what are the risks of doing that? What I fear long term is that good people, policing is going to become sort of this, I don't know, old people like me, Peyton Place kind of, I don't know if it resonates with the younger crowd, but, this sort of, the entire profession will be tainted with this whole aura of sexual allegations and all that, because let's face it, I think the sponsor of the bill pointed out, you want to get even with a cop, just say something. They can't, nobody can prove it, that it didn't happen, or he didn't say that, or she didn't say that. So the challenges we face is that we're going to basically take this profession into the dumps, and good people who are in college now, who are in high school now, who want to come in, are going to say, I don't need that stuff. And the people that are there who have other options will pursue them, and will end up with further harming the public safety. The New York court did not say, this is good public policy. The New York court did not address the public policy. The New York court said, the legislature acted, and we give deference to the legislature, and under those standards, there's nothing here. They never said they didn't in any way support the public policy, and what was proposed was an injunction. They said they failed to meet the standards for an injunction. We've heard the parade of horribles that is supposedly there. We've heard the anecdotes. But I just ask you, when you look at that, to factor all this in, all these other changes we're making, factor in the potential harm this will bring. Look at our own situations, because quite frankly, if it doesn't fit for us, it doesn't fit for them, and vice versa. Thank you.
Thank you, Senator. Chair recognizes the chair of the committee.
Thank you, Mr. President. I'm going to ask the body to resist this amendment. I'll join with my colleague and the sponsor of the bill and the floor leader. I struggled with this bill. I've actually, I've co-sponsored this bill in the past, and I've supported it, and it doesn't mean that it's an easy call. And I understand the maker of the amendment. I understand the arguments that come behind, because this is difficult. You're asking for, and we're going to have the disclosure of disciplinary records ranging from unfounded, unsustained, all the way through to some of the more terrible things that people have done and that should be on their record and should be memorialized, and everything in between. I'll just go back to what the sponsor of the bill started with, was that right now we have a system in which there's just a complete cloak over information. Something like 90% of these allegations that are unsustained, we have no idea, we have no window into what's happening. A key element in terms of restoring our trust with our relationship with law enforcement is transparency. And kind of my North Star throughout this most current, or this iteration of the debate, has been what happened in New York, because I think it's instructive. The Second Circuit came down with an opinion, and they cited a lot of the rationale that was discussed in the district court. And one line that in particular kind of stuck with me, that gave me comfort with this bill, was that they said, look, the district court noted that the future employers, there's an argument that having this information out would kind of handicap people's ability to have future employment prospects and would damage their reputation. And the sponsor of the bill and the floor leader mentioned this earlier, but I just thought reading it from a decision, I think, was compelling to me. The district court noted that future employers were unlikely to be misled by conduct records that contained dispositional designation specifying that allegations of misconduct were unsustained, unfounded, or that the accused officer was exonerated. That means that once you put the record out there and you have the final disposition of the investigation and the person's exonerated, or it was unfound or unsustained, that cleanses the allegation, and that is out there. That's part of the public record as well. And so that gave me comfort. And so for that reason, I'm going to ask the body to resist this amendment. I think this is good policy. It'll allow for us to have transparency. It'll protect the reputations of the officers because all of that information will be out there. So with that, Mr. President, thank you.
Thank you very much, Senator. Chair recognizes the Senator from the 42nd District. Judicial Proceedings is a strong voice on the floor today.
Thank you, Mr. President. I can't understand the speech of the floor leader extolling the making public of false information about people. I think that to the extent that social media transmit lies and out-and-out falsehoods about decent people, we're all endangered. As a society, we're all hurt. To defend this bill by stating that any of us could at any time be the victim of malicious social media postings doesn't persuade me to support the bill. Earlier on, the senator from Anne Arundel County gave a hypothetical scenario. I've got another one for you. We all remember what happened in New York in Central Park when the black gentleman was standing in the park with a set of binoculars bird watching, and a white woman walked by and filed a 9/11 complaint against the black man. Let's transpose that situation to Maryland. Suppose there's a white woman driving in a car down the street, and a black officer follows her and pulls her over because she has a defective taillight. She, for whatever reason, takes offense that she's been pulled over, and she files a malicious complaint against the officer, complaining that he tried to engage her in sex while stopping her on the side of the road. That complaint is subsequently investigated and determined to be completely fallacious. But under this bill, there's a good chance that that complaint is going to be made public, and it will find its way into the newspapers, and it will certainly find its way onto social media. And once it's on social media, the officer's children in school are likely to be harassed and bullied because of the false complaint made against their father. This bill would permit that. This bill would facilitate that sort of information being disseminated on social media, which could destroy a man's reputation and destroy his career. And the key is that the information is completely malicious and completely unfounded. Just as I can't imagine supporting the idea that social media would purvey falsehoods about people and we should be amenable to that happening to us, neither can I support this bill, which provides that incorrect, unmeritorious complaints filed against police officers can be made public in a way which would destroy their lives, destroy their reputations, and destroy their careers.
Thank you, Senator. Chair recognizes the Senator from the 40th District.
Thank you, Mr. President. Question for the sponsor of the amendment.
Will the floor leader yield to a question? Excuse me, the maker of the amendment. Yes.
On
Senator,
the amendment, it identifies a date of October the 1st, 2021, in which this bill would be in effect. Is the goal is to not have the things disclosed that happened previously?
That is that's the effect of the Part 4 of the amendment.
I guess, members of the Senate, the problem with that is I know that it's been very publicized throughout the state of Maryland in the activity of the Gun Trace Task Force. And for those of you who may have forgot the actions of the Gun Trace Task Force and the effect that they had on citizens in Maryland, I want to take a moment to remind the body of some of those things. And in some of the actions that this task force took, officers would allegedly drive fast as a group of people would quickly slam their brakes, hoping to scare them to see if they would start running, therefore give pretense for a chase and search. Then, this allegedly happened 10 to 20 times on slow nights and more than 50 busier nights. The officers also allegedly used illegal GPS trackers to chase down targets for robbery. In July of 2016, the officers allegedly picked up a married couple, even though there was no evidence of any crime, found out that the couple had $40,000 inside in a house outside the city, and proceeded to scour the property for cash. They took $20,000 before they called other law enforcement to the home. In another case, officers took a man's keys, found out where he lived through police database, and went to the house where they found drugs and a safe. They allegedly took $100,000 from the safe, which had $200,000 inside. And during 2015, in the neighborhood that I grew up in Penn North, after the death of Freddie Gray, one officer allegedly pretending to stop the looting at the pharmacy that a lot of the seniors in my neighborhood depend on to get their groceries, to get prescription drugs, took advantage of that opportunity to loot that pharmacy himself. And so this amendment that only covers from October the 1st going forward does not allow the opportunity to disclose those terrible actions on behalf of Maryland citizens. And so, members of this body, I urge you to reject this amendment.
Thank you, Senator. Chair recognizes Senator from Frederick County.
Thank you very much, Mr. President. And I'd like to say overall on this package, I think the committee did a good job. And we operated under the principles of punishing bad officers, removing them, and even creating new criminal penalties when they do things just like the gentleman spoke before me from Baltimore City mentioned, to really hold those people accountable. New citizen overview or new citizen oversight boards, criminal penalties on police officers that do terrible things. So the package overall is good. And one thing about the package that we do put in on a number of other bills is fairness and due process for good officers. Unfortunately, this bill, as it's currently constructed, doesn't do that, and the amendment would fix that. Because the fatal flaw in this bill, and what the amendment is getting at, is unfounded and false allegations becoming public. And the Senate President, in the beginning of our session, talked about, I was thankful that you did that, Mr. President, some of the activities by people who are, I would say advocating around this legislation. And I just want to say personally, most of the activities and the things they've done have been at my friends across the aisle, and my colleagues across the aisle. I've seen some of the most disgusting things on social media attacking the moral fiber and character of my friends across the aisle. I've seen protests at their house. And to act that if these individuals, these groups and these activists that are doing this, that if we then empower these people with false allegations, unfounded allegations, that they somehow are going to be responsible actors with that, Mr. President, quite frankly, that's absurd. If we allow false and unfounded allegations against our police in the hands of these people who right now are personally destroying members of this body's, attacking their character and their fiber, showing up at their house, can you imagine what they'll do to our police officers? They will do the same thing. And it reminds me of, and I'll just leave it at this, it reminds me of, I remember President Reagan had a secretary, I think it was his, I can't remember, education, one of his secretaries, who was charged criminally with something, had to resign. He went to court, and like 2 years later, he was acquitted. But you imagine being a secretary, I mean, it's in the Washington Post, everything. They went to him and they said, what do you have to say? He says, where do I go to get my reputation back? Once these allegations and things are out there, where do our officers go to get their reputation back? And the behavior that we have seen to our friends in this, to my friends in this body, to think that these are reasonable people will do reasonable things with false allegations, I think is absurd. And I think the protest that happened at lawmakers' houses this weekend speaks further to what will happen when this false information is given to the hands of people who are looking to destroy people's lives. So let's not put our officers in that position. Let's not put unfounded and false allegations in people's hands to destroy people's lives. And I would urge the body, support this amendment. Many of the concerns that were brought up the rest of the package addresses in a fair way and punishes bad police.
Thank you, Senator. Chair recognizes the senator from District 9.
Thank you, Mr. President. Would the maker of the amendment yield for a question, please?
The amendment maker yield appears so. Senator may proceed.
Thank you. I've been trying to see you. I've been trying to follow this bill really closely because it's been an issue, and several constituents have called me about it on both sides. I might add. And my question is about the timing for when the allegations are made and when the information becomes public. And I'm just wondering if you could describe how that would happen underneath your amendment versus how it would happen under the bill as it is. Because I think the timing is so important, given that people's reputations, are on the line. That's my question.
Thank you for the question, Senator. I'm not really sure on the exact timing, but in the end, the allegation does become public record, even if it's investigated and unfounded. So maybe the maker of the bill can explain exactly when that happens. All I'm trying to do is keep the unfounded ones, after they've been investigated and unfounded, unsustained, from going into the public record that can be obtained by the, a PIA request. So I'm not sure exactly when it becomes public.
Maybe the maker of the amendment may want to yield to the floor leader.
Thank you, Mr. President. I'll yield to the floor leader.
Thank you, Mr. President. So in an effort to answer your question, a record under the bill, this bill, the bill that the committee has put forth, is potentially disclosable, or there's a permissible disclosure following an investigation and a finding. So that's the first thing I want to make it clear, because I do believe I did hear from one of the senators across the aisle that this could taint an investigation if this were disclosed. So if it's an open investigation, it's not going to be disclosed, most likely, because the custodian of records can't disclose a record that could taint an investigation. So it's once there's a finding. So there is no specific time limit, but the issue on time is that under current law, an officer has an ability to scrub the record, the complete record, after 3 years if an allegation is not sustained.
Okay, I think that's helpful. And the follow-up question would be that.
Senator, is this to the maker of the amendment or to the floor leader? Why don't the senator should ask the question, and we'll find the right.
Thank you very much, Mr. President. I'm really trying hard to understand this. So the question is, with these false allegations, what is the protection that the officer, has,
So the protection that the officer has, first of all, is that if it's somehow imprudent under the bill, it's not going to be disclosed, because this is a whole process. And I want to really briefly talk about that process. So any police agency, all police agencies are going to designate their own custodian of records that is going to be the person or persons that vet whether or not something meets the criteria under the bill to be disclosed. 99 times out of 100, that entity is going to either be working in concert with agency legal counsel or be agency legal counsel that's going to make the determination. So I want to make it clear that these are reasoned determinations. It's not just willy-nilly, let me submit a request for all of these allegations to be disclosed, and there's no real vetting process. Number two, I've heard today, and I just heard from one of the senators across the aisle, who kind of put together or combined the concept of a false allegation and an unsustained complaint. I want to make it clear that there is a difference, technically, between a false allegation and unsustained complaint. We know through just looking at our regular judicial system that a not guilty finding is not necessarily actual innocence. We know that there can be something that's completely false that's different than something that simply wasn't sustained. Not sustained means maybe there wasn't enough evidence to sustain it. Not sustained means maybe we don't really want to deal with this issue, so we're not going to conduct a thorough investigation and we're just going to deem it unsustained. Like, that's what actually we found has happened, and data reveals that happens quite a lot. So unsustained complaints along with sustained complaints would be disclosable under this bill.
That's very helpful. Thank you. Could I just follow up with one question for the maker of the amendment?
Will the maker of the amendment yield? Clear. So, Senator may proceed.
So now that I have a better understanding of the timing of the process, I'm still concerned about the frivolous complaints. Would your amendment eliminate the frivolous complaints?
If a frivolous complaint obviously would be unsustained because it's frivolous and there's no evidence, this amendment would take care of that. It would not be in the officer's record to be obtained by the public information.
Okay, thank you very much.
All right, Chair recognizes the senator from District 17.
Thank you very much, Mr. President. If the sponsor of the amendment could yield for another couple questions.
Senator may proceed.
Thank you. So the senator, the good senator from District 40, confused me a bit with his example. It says in the amendment, Section 4, any record relating to an investigation under paragraph 1 of the subsection that was adjudicated, closed, completed, or otherwise resulted in disciplinary action on or before October 1st, 2021 is a personnel record. So basically, if it's already been completed, there was either a problem that was addressed, or you were deemed to not be guilty or in violation of any particular issues by this October, then this bill wouldn't apply. It wouldn't be public. It's only if it's pending. It sounded like the senator from District 40 was saying that currently pending issues would then not be governed by this. So that was a little confusing. Can you just clarify that, please? If there is a case that is currently pending and it has not been adjudicated, it has not been deemed to be either problematic or not problematic, then it could still be investigated, correct?
Yes.
Okay, so that's the first thing. So if there is something, whether it's from Freddie Gray or some other horrible incident, we're not wiping the slate clean. We're not giving them a get-out-of-jail-free pass. We're not saying it's no big deal, we'll look the other way. You're still on the line until we either say, yes, guilty or not guilty.
That's my understanding.
Okay, then the second thing that I have to ask, and as a non-lawyer, sections 1 and 2 in the amendment, the first one talks about clear and convincing evidence, and the second one talks about the preponderance of evidence. Could you just please explain that clearly for us so we can, either with or without an example, just so we're clear as to what this would cover?
To my kind senator that represents Rockville and Gaithersburg.
Sorry.
I'm not an attorney, so I had a lot of help with this amendment. But it's my understanding that first, if there's not clear and convincing evidence that it's not going to be on the officer's record. There was no clear evidence that this occurred, so we're really talking about unsustained. Or after an investigation, hearing board, third-party, neutral, other authority with jurisdiction that there was insufficient evidence. So there really needs to either be clear and convincing evidence, or if there's insufficient evidence, it's not going to go in the officer's record.
I appreciate that. Thank you. Thank you, Mr. President.
Thank you, Senator. Chair recognizes the senator from District 10. Chair of Finance.
Yes. I'd like the maker, the floor leader to answer a question about the amendment for me.
Will the floor leader yield?
Yeah. If the person who makes the allegation could either be telling the truth, they could be lying, or they could be misguided. And would you say that's 3 different situations?
Yes.
Okay. If the person...
Madam Chair, just reminder to keep your microphone close so that we can hear you.
If the person is either lying or misguided, wouldn't it be as important for the public to eventually find that out after an investigation as to find out if the person were found to have been wrong in his carrying out of his duties?
Well, my answer to that would be yes.
And if we don't allow, in a case where after an investigation, because the press, people who make allegations usually go right to the press, so they'll get press attention. So the allegation is the thing that begins to harm somebody's reputation. If the allegations are upheld, then I think we all would agree that should be known. If the person is misguided and they don't understand the law, or they don't understand their circumstance, or they don't understand the way things work, we need that to be made clear to the public. And if you keep the outcome closed, the public never knows that what they heard initially on the 5 o'clock news ought to be taken in a totally different light. That the person might have been accused, but the person making the accusation either lied or they were misguided and didn't understand the law. Wouldn't you say?
Yes.
And then in the few instances, so however many, where the person's allegations are sustained by the investigation, it's also important to all of us to know that that outcome, where truthful, is available to us. Would you say?
Yes.
I'm trying to understand where the downside is to the officer. It seems to me, if you've accused me and you were either lying on me and your allegations are not upheld after the investigation, I would want my neighbors and my friends and my family to know that this didn't work out the way the person described it, that I am exonerated. And you don't know if you can't say what the outcome of the investigation is. Isn't that the case?
Yes.
And then if I were misguided and I didn't understand the law, I was, I would want that to come out if I were the person accused because somebody was ignorant of the law and how it worked. I think I'm better off if I go to a different state to get a job. The fact that I can show a newspaper article that shows now these allegations were not sustained, it helps me. I can look people in the face. I can go back to church and worship with other people who used to respect me. And they know that what I was accused of was something that somebody misguided or somebody lying said. And now there's been this official investigation, and I can look everybody in the eye. I can look my children in the eye again because it shows I'm not guilty of anything, doesn't it? So I think you hurt me, really. You're trying to help me. But the fact that the allegations aren't hidden, people who make terrible allegations against you are going to the press. We can't stop that. Yes. I want, if the allegations are eventually unfounded after a proper investigation, I want people to know I didn't do it, or it was misunderstood, or it didn't apply to what I was expected to do to carry out my job as a law enforcement officer. So it seems to me that once the allegation is out there, the best way for me to protect my reputation is for the finding also to be out there.
Yes.
Thank you.
Thank you. Senator Chair recognizes the Senator from Prince George's District 24 on the amendment.
Yes. Could the maker of the amendment please rise for a couple of questions?
It appears so. Senator may proceed.
I'm sorry. Thank you, Mr. President. Now, this amendment, is it designed to remove unfounded, non-sustained, or exonerated cases from the proposed bill? Is that what it's designed?
That's correct.
These three categories?
That's correct, Madam Senator.
Can you cite for me another profession that would allow these three cases, these three instances, to be made public? Do you know of another profession?
I do not know another profession that would allow that.
You all know that I'm an educator, very proud of that. This would not occur in my profession. It would not. When the case goes to Baltimore and it's investigated, if a complaint is made with the local school board, and the school board even rules in favor of the complainant, it goes to Baltimore. But that information does not become public, because in Baltimore, they can look and make a decision. It doesn't have any merit. Now, in the case of the police officers that I'm concerned about, these personnel records could be used as a basis for which to deny promotional opportunities or career advancement, with the potential to further complicate employment for these minority officers. And I can cite for you all case after case after case. And you heard me ask the question about, are most of these complaints internal? In the case of the officers that I am working with, and the information, the paperwork that we're looking at, most of the complaints have been internal. And it gets in the way of these officers, even though they are forced to resign to get jobs with other agencies. Some, they even question them being able to carry a firearm. That is why this amendment, I feel, is so important, because we need to protect not only minority officers, but all officers. Because there are officers who, if they disagree with their supervisor, they are targeted. So it's a whole lot involved in this, my wonderful friends. When a complaint is determined to be unfounded, it means that the allegations carries no foundation or basis in fact. When a complaint is not sustained, it means there are insufficient evidence to prove or disapprove the allegation. When an officer is exonerated, it means the officer's actions were in compliance with the departmental policy. I am very concerned that without this amendment, it will not help officers of color who are trying to move into promotional positions or any position, even after they have left the police department or the state police. And I'm telling you all, this is where the rubber hits the road, and this is where there is a thorn in the side of these police officers who have given years of dedicated service. Because once this information goes to public, I don't care what you say or anybody else say, because the public, once the information gets to the public and it becomes a part of the Washington Post, the Baltimore Sun, Channel 4, 5, 6, 7, and whatever else, people immediately draw conclusions. And they look at you as an officer from a different perspective. And that's why we need to be sure that the information, if these people have been found not guilty of the complaint that's been lodged against them, we should not allow it to become a public football and create sadness for not only the police officer now, but the police officer's children. You all know I'm hot to trot on children. Families, friends. That is why this amendment is important. And so I once again want to ask you, is this amendment designed to deal with these three cases? And do you know of another profession where these cases are allowed to become public without the police officers or without officers being given the opportunity to determine whether or not they're not determined, they don't get their day in court. They're guilty before proven innocent if it goes to the public. Because I know public perception. I've been around a long time, as you all know. But once it gets to the public, and we're dealing with cases around the country right now where people are drawing conclusions without understanding the facts. And the senator from Baltimore County is absolutely correct. A lot of times complaints are large and they have no clue as to what the process is. And so I'm just wondering whether or not what I'm thinking over here in this little corner is what you are proposing. Is that not so?
That is so, Madam Senator. Thank you for your questions and your comments. And if I can add, as we talk about this profession, my police chief, who is a wonderful minority woman police chief, we're so happy to have her, tells me that recruitment is really down, where she typically can have a class of 35 new police officers coming into the department, and where she can recruit black and brown officers, she now is having a tremendous difficulty doing that, and the classes are down to less than 20. So it really is affecting, I think, the climate for law enforcement officers. But I thank you for your questions and your observations.
Thank you.
Chair recognizes the senator from Baltimore County District 11 on the amendment.
Thank you very much, Mr. President. I have to say, I was very skeptical about this issue last year. And I had some folks in my office, and we had this conversation about whether unsubstantiated claims should be made public. And so I struggled with it for quite some time. And I have come to a place where I really do believe they should. And they should be made public. And I rise today to urge my colleagues to vote against this amendment. Mr. President, could I ask a question of the floor leader, please?
The floor leader or the maker of the amendment?
The floor leader.
Floor leader. Will the floor? Yes, appears so. Senator may proceed.
And I just want to talk a little bit about how I came to this conclusion. One of the things that I have decided is that there are real problems with the system. And there are real problems with the internal systems by which the police departments come to the conclusions of whether the complaints are substantiated, unsubstantiated, or unfounded. Is that the case in your mind?
Well, that's not just in my mind. It's also evidenced by the Department of Justice report that highlighted specifically Baltimore City in their report in mentioning that one of the greatest problems why there was no accountability was the fact that complaints from the public were not adequately investigated by the agency.
Okay, and one of the actually I'm looking at one of the reports right now, and it talks about the nature of these complaints. And some of my colleagues have mentioned some things that might be considered to be frivolous and some that are, could be fabricated. But I'm reading here about complaints about false arrest or imprisonment. Is that kind of one of the topics that there are many complaints about?
Yes, false arrest, false imprisonment.
How about excessive and unnecessary force?
Excessive force.
Planting of evidence. Complaints of theft. Have you heard about domestic violence?
Yes.
DUI, DWI, hit and run, are those some of the complaints that are made against police officers?
So I would say most of the ones that you mentioned, yes, because we're talking about the allegations made from the public. Generally, the DUIs are made within law enforcement because they've committed a violation of the state law.
Okay, and can you talk, is there a disparate way that people are treated, A, with regard to the race of the complainant, and B, if you could speak to the race of the officer?
Yeah, well, there was a recent report that came out in January, and you may have access to that in front of you, I'm not sure, but basically it found that there was a great disparity in determinations of complaints being founded, a much higher percentage when the complainant was white. Complaints by black members of the public were rarely sustained or much less frequently sustained.
Thank you. Thank you very much.
On the amendment?
On the amendment,
Senator,
yes.
may proceed.
I come to the conclusion after doing a lot of reading and a lot of thinking about this, and it is my belief that shining a light, that light is the best disinfectant. And perhaps a number of years from now, after these bills go into effect and we have had some reform of the system, I may come to a different conclusion. Perhaps then, when I have great confidence that unsubstantiated means unsubstantiated and unfounded means unfounded, then I would agree with my colleagues who are asserting that those should not be made public. But for right now, when there are so many questions to me about how the system treats these complaints and how the disciplinary process works, and is it working effectively, and is it holding people accountable, I err on the side of sunshine is the best disinfectant. Thank you very much.
Thank you.
All right, we're going to go to senators who have not yet spoken. Chair recognizes the senator from Frederick City.
Thank you, Mr. President. I felt, rather than commenting why I voted afterwards, I'm going to talk now. I fall somewhere in between the two positions here, but I lean towards voting for the amendment. I have a bill in that may or may not come to the floor, but it relates, and I just want to explain that, and it explains why I'm going to vote the way I do. I have a bill in that says if a woman's sexually assaulted and the prosecutor decides not to go forward with it, that she should be able to call and get an explanation. The explanation may be as simple as, we didn't think we could prove it, but at least she gets an answer. Well, in this case of this bill, I think people deserve an answer. I think if a board finds guilty, then the public should know. If they find not guilty, the public should know. But if it's unsustained, you don't know which one's lying, or if they're both telling the truth and it's just a difference of opinion or whatever. I can see that going on an internal record that's kept, so that if a lot of those occur, you can begin to look at it differently. So I think that someone should be able to call and get an answer, whether it was sustained or it wasn't. But making it on a permanent record and making it public, it's public in both cases, but there's a difference of how public it's made. I think the person that accused should get an answer. It was unsustained. But putting it on the record and making it available publicly that can end up in paper and social media and whatever, I think is going too far. So that's why I'm leaning towards the amendment. I think we need a correction. I'm just not sure. I want to stay in being fair to the police until we have a solution that I think is fair to everybody. And I think with the amendment, it's a little fair. Thank you.
Thank you, Senator. Chair recognizes the senator from the 47th District, Prince George's County.
Thank you, Mr. President. The floor leader yield for a question. And
will the floor leader yield? Appears so. Senator may proceed.
Thank you. And just to start, I think that we respect law enforcement, but we invest in them the power of life and death. That is the power that we invest in them. And my question for you, I just feel that this has kind of gotten away from the name that is up on there, which is Anton's Law. Can you bring to me the nexus between Anton's Law and this piece of legislation?
Thank you for the question. So Anton Black was a teenager in Greensboro, Maryland, who was killed by a law enforcement officer in 2018, I believe. And since that time, I've had occasion to speak with his family and especially his sister, LaToya Holly, who's become very outspoken about what her family has had to endure. It turns out that the officer responsible for killing Anton Black, who was unarmed and who posed no threat, was let go from another police agency. It wasn't in Maryland, but there were complaints that that officer had against him that did not bar him from being able to come to Maryland and work. And so the family of Anton Black, like the families of all victims of police homicide and police brutality, has been unable to get access to the investigative file of the officer within the agency because it's not disclosable even to the victim or to the victim's families. And so that the impetus for the bill was the teenager Anton Black.
Thank you. I appreciate that response. And with regard to the amendment, and it's still for the floor leader.
On the amendment. Oh,
On the
question.
amendment.
Senator may
Yeah.
proceed.
It's just I need her help if you appreciate it. So my understanding is that, well, first of all, I just want to share that there is a tremendous amount of, at least I know, about a fear that occurs with a significant amount of Marylanders, including myself, quite frequently when we interact with law enforcement. And that's a historic fear that we have. And it's a fear that extends to perhaps our willingness to come forward or to talk about an incident that may have occurred to us, which could that not lead to something being unsubstantiated? Could that not, or could these things not show a pattern if we saw that these kinds of things were occurring?
Yes, one of the benefits to the bill without the offered amendment is that what the amendment would do is it would preclude us from being able to potentially flag officers that were recipients of multiple allegations. Because again, all of the reports show that a small percentage of officers in most agencies are the recipients of multiple complaints, majority unsustained, and no disciplinary action taken. And so this would be designed to give us guidance and be able to flag those officers that are problem officers and frankly help the agency do a better job in making sure they are conducting fair and substantive and effective investigations.
Thank you so much, Floor Leader. Colleagues, it
On
is...
the amendment, Senator may proceed.
Yes, on the amendment. It is with that in mind that I would ask the body to resist this amendment. I think that it's very clear that we are not trying to negatively impact the careers of law enforcement. Not at all. We respect them. But we are trying to save lives. And I believe that that is what this is about, and that's why I'm going to vote no on this amendment. Thank you.
Thank you, Senator. Chair recognizes the chair of the committee.
Thank you, Mr. President. Just back on the amendment and back to the Senator's specific question about the differentiation between employees and records being disclosed and what other professions do we require this. And look, throughout this entire discussion, I've tried to kind of deploy the Newtonian principle of order and balance. How far can we push to make sure that the systems are correct, but how can we also not make this about penalizing the profession? And I think we've done that here. We've struck that balance with making sure that we're addressing the systemic problems that have borne out and given us some terrible results over the course of years. And I think this bill is in line with that. And again, I just keep going back to the Second Circuit decision because it's fresh. I mean, it's on point and it's fresh. And again, in New York, in that Second Circuit decision, they talked about the union brought forth an equal protection claim, saying that, well, why are you disclosing these records and not records of other employees? And the court kind of dismissed that claim because it said that even the unions have recognized that the unique responsibilities of law enforcement, that they're unique, they're different. They carry weapons, they have the ability to incarcerate, they have tremendous responsibility to protect us. It's just different. And we've struggled with the difference between a law enforcement officer or a court clerk or a teacher. We've struggled with that. And we have to understand that it is different. And so they said that, look, the public has a stronger legitimate interest in disciplinary records of law enforcement officers than those of other public employees, and that there was a rational and non-discriminatory basis for treating these two records separately. Again, I just keep going back to that decision because it is fresh and on point, but we have to understand the differences between the profession of law enforcement and other professions, and I think this adequately addresses that. This coupled with, again, the 7 criteria that the sponsor spoke to earlier, the fact that there's a process, there's a custodian of records that has to wash through this. There are several layers of decision-making and analysis that go into this. And so for that reason, I just wanted to point that out, that there's a reason that there's a difference. And we'll thread that needle throughout this package, and we'll continue talking and having that conversation, but I just wanted to clean that up. So thank you, Mr. President.
Thank you, Senator. Chair recognizes the senator from the 34th District, followed by the senator from Baltimore City County, and then we'll with the maker of the amendment. So, Senator, 34th District.
Yeah, thank you, Mr. President. I just rise briefly to make a couple quick points. First, in response to the chairman, my challenge with the Second Circuit opinion is that they make the ludicrous statement that there was no evidence produced that having your name put forth before the entire world on the internet with spurious allegations would in any way affect your life. And I'm sorry, but that's just ludicrous. And all they were saying was that the union who was the challenging the lawsuit in that had failed to put forth evidence of people whose lives had been changed because they had been damaged by spurious allegations on the internet. Surprising to me because since I've been in Judicial Proceedings Committee, we've addressed a slew of bills exactly on that point to address people's lives, everything from minors to all the way up, and we've heard endless testimony, people whose lives were destroyed by just simply, not necessarily false, but just spurious allegations made on the internet that destroyed their lives, their families, etc. And in some cases, literally their lives through suicide. The other point I want to make is that my colleague from the committee, one of my other colleagues, said that we're not really sure about this. Maybe we're going the wrong way, but for now we'll go this way. See, that's the challenge we make, and that's the problem we have in anything we do with criminal justice, is that unlike, do we raise the price of gas or lower it, or raise the price of soda or lower it, we'll figure out if we didn't do it right and we'll adjust. Unfortunately, in the criminal justice system, the changes we make take a year or 2 or 3 or 4 or even 10 to manifest themselves, and by that point, the damage is very serious and done. But my real point I want to make on that one is that we address that allegations or incidences of theft and DUI and domestic violence. Colleagues, none of those are implicated in this bill. If you have a DUI challenge, that's a criminal challenge, that's on the public record, has nothing to do with this bill. If you have a domestic violence case, that's on the public record, that's not affected by this bill, and in both of those, the officer will certainly, their ability to carry would be pulled, and they have serious problems. There's an old adage that bad cases make for bad laws. There have been serious failures in at least one jurisdiction in this state, serious failures of policing that have caused them to bring in the Department of Justice. We don't do that everywhere. Literally bring in the feds to come in. We had basically a total breakdown of the system. They're there. There's consent decrees. There's a lot of totally unusual things going on to try to correct that. We ought not look at that and say, let's use that as a template for all of the other jurisdictions in the state. It's a systemic failure. Bad cases make for bad laws. We have to be very careful of that. We look at what the potential harm in the other jurisdictions should get substantial weight under these circumstances. Clearly, if your jurisdiction is under Department of Justice decree and your policing system has failed, it's a new game in town, but we shouldn't institutionalize that. Thank you.
Thank you, Senator. All right, we have the senator from Baltimore City County, and then the maker of the amendment.
Thank you, Mr. President. I had a question for the maker of the amendment.
Question for the amendment maker. Senator may proceed.
Thank you. If I could you help me to understand within Section 3 why you chose to have these two different standards put forth for records that you don't want to go out to the public?
I'm having trouble hearing your question, Senator. Would you repeat, please?
Sure. Under Section 3, Roman 1 and Roman 2, there's two different standards that have been put forth. I'm curious to know why you felt the need to include both of those standards.
I believe they're really very different because one says that after the investigation, they determine that there's no clear and convincing evidence that the infraction did not occur, and then in the second one that there's insufficient evidence. So I think preponderance means at least 51% proof, but I'm not positive. But I think the two really address very different issues that need to be addressed in the bill.
Okay, and in Section 4, is it the maker's intent to shield all previous investigatory records that have happened up through October 21 of 2021, or October 1st of 2021?
I'm not sure I agree with the word shield, but since those investigations were completed under a different law, I think that if they're an ongoing investigation, this is still going to apply. But if they're closed investigations, they were hearings under a different law, and I think that those should not be part of the Maryland public information request.
Thank you.
All right. Chair recognizes the maker of the amendment, followed by, I believe, our last, the floor leader. So, maker of the amendment.
Thank you, Mr. President. And actually, my question is for the chairman of the committee, if he doesn't mind.
The chair of the committee yield. Pearso. Senator may proceed.
Thank you, Mr. Chairman. I appreciate your comments today. So I really appreciate the package of bills that have come out of your committee, and I think a lot of good changes have been made this year. And so this is just one piece of all of those packages going forward that I think are going to improve what we're seeing in our police departments. And apparently listening today, there are a couple of departments that have not done a good job. And I feel like this particular bill is punishing all the police officers, even the officers that have done a good job in good departments, because of some bad actors. And I really, you talk about the disciplinary records, but it's not a disciplinary record if it was an unfounded allegation. And that's really what this amendment's trying to get to. So I agree, some departments have failed, but wouldn't you agree that in most cases things have been handled better in probably 95% of the counties and the departments, but that your other bills are going to make a civilian review board and things are going to be really handled in a very different manner than the past. Would you agree?
Oh, there's no doubt that the package as a whole changes the system as we have it now, and I think makes it more transparent and holds people more accountable, and you can focus in on a single kind of point of accountability. So there's no doubt. I will say that I also believe that this bill is a critical cog in that wheel, and part of that transparency. Like the senator from Hartford County said, this package works together. So this is a critical piece.
So my very last question to you, Mr. Chairman, is that just because a record is not disclosed under public information doesn't mean that the police chief or the administration doesn't have a record of all those infractions that may have occurred. So if you see if a police chief sees an officer that a couple of times gets charged with force or some other disciplinary action that was unfounded, he or she can see that pattern. Just because it's not exposed to public information doesn't keep the pattern from being followed. Is that correct?
No, that's absolutely correct. But what is also true is that we would have no idea as to whether the chief was taking the appropriate action because we don't know. We have no access to those.
But, Mr. Chairman, in the bill that we haven't addressed yet, LEOBR, we've given a lot of authority to the chief, and now I hear doubt from you about the ability of the chief, and that concerns me.
Well, we've given the authority, but we've also given the transparency. And so, we have now accountability with that. We can see what's going on from soup to nuts. And so, yes, we've given a chief more power here, but we've also given the general public and everyone in this room the ability to see exactly what's going on.
Thank you, Mr. Chairman.
All right, I believe a final word on from the floor leader.
Thank you, Mr. President. Members of the body, I stand here and urge you to resist this amendment. This amendment would completely destroy our ability to have the transparency that is warranted, that will help us, one, ensure the integrity not just of individual police officers, but of police agencies across the state of Maryland. Now, a recent report that was made public out of Prince George's County highlights a scenario that I want to speak about, which demonstrates how this amendment would destroy our ability to know things like this. Corporal S1 received at least 8 complaints from black male civilians that he inappropriately touched their genitalia during traffic stops. These matters were referred to his command staff, which included Major Mills and Lieutenant Finn. Corporal S1 never received discipline more serious than a reprimand. The report also details white rank and file officers who used racist language, including the N-word, made racist comments, lazy black officers, at least slaves had food and a place to live, you are lucky to be working in this country, you should bring back public hangings. These officers were not disciplined at all. The few that were never seriously disciplined. These are the types of situations, and it's just a snippet of the mass number of public complaints that we never know about. We never know, and we never will know, anything about this large body of complaints and large body of violations if we accept this amendment. We've got like 2% in some agencies of sustained findings when it comes to use of force, even when there's been criminal convictions. This amendment would destroy the intent and the spirit and the transparency of this bill. We would not be the first state in this country to do this. If we are serious about what I've heard many contend, about restoring trust in policing, about making sure that we have integrity in policing, and let me just say this. See, I don't agree that disclosure and transparency and accountability will destroy someone's desire to be a police officer. I actually believe those honorable persons that want to be sheroes and heroes will run more quickly to this profession, knowing that being a police in Maryland is something that is taken so seriously, that lack of integrity, that misconduct, that staying on a force with 44 and 64 violations of the public trust is something that is never going to be tolerated. The only way we're going to get to that is if we pass this bill without this amendment. We will never, ever, ever know of these incidents, as Chairman Smith said, if we adopt this amendment. Now, I understand our desire and our sympathy and our empathy for our chiefs and sheriffs. This is not about that, though. This is about us doing our job to help them be better, because that's what we're here for. We have to make them ensure that they are better. We can't let them tell us how to govern it. We have to make those decisions. We are entrusted by the public to do that. And we're talking about a violation of public trust. Policing is a public function. And it is unlike any other profession because decisions that are made are often final. There is no appeal from death. There's no appeal from that. And so you have to understand the gravity of the situation. If we are serious about restoring trust and having accountability and transparency, this is an essential piece of that puzzle. It's an essential part of the overall package that we have to produce. There is no other choice. We will never be able to ensure integrity if we don't have the transparency to know how these agencies are investigating these kinds of public complaints by these public officers with public salaries that perform public functions. That is our job. And so I am urging this body to resist this amendment, honor the committee's report, the committee's product that took a lot of time, a lot of sweat, a lot of heartache, a lot of debate, a lot of consideration. And at the end of the day, we made a decision that we thought was in the best interest of the people of Maryland. Thank you.
Thank you, Senator. I think we know the issues. But it does look like there are senators who wish to speak. Chair recognizes the maker of the amendment.
Thank you, Mr. President. What I just heard was that we don't trust the chief to make the decision. We don't trust the review board to make the decision, even the civilian review board, that we still need to put up our officers who have had unsubstantiated complaints because we don't trust the people that are judging them. And that is of a great deal of concern to me. So I just wanted to close with those final words. Thank you.
Okay. Chair recognizes the senator from the 34th District.
Mr. President, I just rise because sometimes the debates, we've spent 60 or more hours working on these things, and we tried to keep the debate logical and forced on logical, and I appreciate my colleagues doing that. But in all this, there's a subtext here that we got to look at, and that's that people are dying in the streets. By the hundreds, they're dying in the streets in our cities, in our towns, here in Maryland. They're dying. And it's not because they're being shot by the cops by the hundred. It's because it's a really dangerous place out there. It's scary. There was a video not long ago of a shootout in D.C. picked up on somebody's Ring doorbell. It looks like an old West scene. It's like just people shooting at random everywhere. It goes on sustained. And it's very dangerous out there. And if we don't be careful, we gotta recognize in all the stuff we do that, yeah, you're right, lives can't be brought back. This is about lives. But the real danger, the big danger, is the one the public faces every day, not from police officers, but from a rising criminal element that's very dangerous and very aggressive and is out to kill people in all of our neighborhoods. And we've got to appreciate that and realize the risk the police officers face. It's a serious risk. It's a deadly risk. And if we don't back them up, they're not going to be there for us. I got to tell you. And it's not I hear people say, no, that's not a choice they have. But having served in combat, it mattered to me a whole lot to know that my community was behind me. That mattered a lot to me. They asked a lot for me to go out and risk my life every day. But the one thing that sustained me in all of that was I knew that in the end, they had my back. My country had my back. I never doubted that for a second. I was given an opportunity one time to go be a contractor. It was a job I really wanted. It paid well. But I watched the contractors. It's another whole other issue, but we don't have their back. We didn't have their back. I was with the U.S. government. They had my back, and I took a lot of risks. And you can't expect people who have families, people who love them, who are waiting for them at home, to go out and take the kind of risk we expect these people to take unless they feel like we have their back. It's important, folks. They need to know that in the end, yeah, we got to get rid of the bad ones. We all agree with that. We've been working on this on all these bills, get rid of the bad ones. But we've got to have their backs. And this bill is going to affect a whole lot of people who are just trying to be good cops, just trying to do their jobs right, who never intended to do wrong. We got to have their backs. And if we have to get some other folks in there who are misbehaving, who are doing really bad stuff, That's what the rest of the bills are about. Jump to the rest of the bills. We can give them the support they need in this bill with this amendment, and in the rest of the bills, go after the bad people who need to get the heck out of the profession and be gone. Thank you.
All right, on the amendment. All right, all in favor of the amendment say aye. Opposed, nay. Chair is in doubt. The clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote?
Mr. President.
Yes, Chair recognizes Senator from Montgomery County.
Thank you,
Has
Mr.
2
President.
minutes.
First, I want to commend all my colleagues for a really thoughtful and persuasive debate. I thought that virtually all of my colleagues who spoke were informed, passionate, and fact-based. This is really hard. My work with 911 puts me in close contact with the police officers, as well as I am deeply committed to transparency. I got an email just now. I reached out to the chiefs in Rockville and in Gaithersburg. And the Rockville chief, because I believe in transparency and accuracy, he said, unsubstantiated allegations against police officers should not be placed online. It goes against the fundamentals of due process and fairness. I have no issues with sustained allegations being placed online. I think that says it all. I voted green for the amendment. Thank you, Mr. President.
Thank you, Senator. Any further senators? Yes, Chair recognizes Senator from District 5 has 2 minutes.
Mr. President, I voted green on this amendment because of a lot of the things that have been said here. And I know we sometimes reach the point in a debate where everything's been said, but not everybody's said it. But I do want to respond to one thing my colleague, who I, across the aisle, the floor leader said, that she believed that this would not necessarily have a chilling effect on people joining the police force, and she hopes for heroes and sheroes to rise to come to join. And I share her hope in that regard, but I'm going to tell you, watching politics right now, all of us in this room know so many good people who now either were involved in politics and have gotten out of it, or will never be involved in it at any kind of level because of the nastiness that we see with the accusations and the constant casting of aspersions. If you're for this bill, if you're for something, somebody finds out on Facebook, they hear that you're for that bill because you own something, or you're against it because you own something else, and all it takes is one kind of aspersion to be cast for an elected official to be tarred and feathered before the truth gets out. Well, can you imagine if we unleash that on our police officers? The ones that maybe somebody makes a mistake, or maybe somebody then thinks that the officer did something wrong, or it's an unfounded error, it's an unfounded accusation. And the news is, if you are policing in a difficult area, you will get some complaints. So that's why I voted green for this amendment. I want us to be able to continue to support our police officers, and yes, go after the ones that have done wrong. And that's what we're doing with a lot of the rest of this package. But this amendment was a smart, common sense amendment, and I urge a green vote.
Thank you, Senator. All right, if there are no further senators wishing to explain their vote, the clerk will take the call. With 26 votes in the negative, the senator's amendment fails. All right, senators, we're gonna pause here. We've got committees coming. I do want to just take a quick moment, and I do want to thank senators. These are really hard issues. There's not an easy answer here, and just want to thank everyone for the tone and tenor and quality of the debate. This is the Senate of Maryland. This is what it looks like, and so just really want to appreciate the quality of the policy making that we're engaged in here. All right, let's do committee announcements. Chair recognizes
Mr. President.
Yes.
You've got further amendments.
Oh yeah, Senator, we're hitting our limit on the time, so we're gonna come back at 6 o'clock.
Okay, I understand.
We'll stop right here, as this will all be unfinished business that will take up.
Finance will have hearings starting at 2:10, and we'll be back here later.
2:10. All right. Chair recognizes the Chair of Education, Health, and Environmental Affairs.
Mr. President, we will do likewise. Education, Health, and Environment will meet at 2:10 for bill hearings.
Thank you, Senator. Chair recognizes the Chair of Budget and Taxation.
Sorry. And I am going to guess that we still go with that. So 1:30 we have budget hearings, and at 3 we have capital budget subcommittee. At 4 we have voting session.
Thank you, Senator. Chair recognizes the Chair of Judicial Proceedings.
Thank you, Mr. President. The Judicial Proceedings Committee will meet for bill hearings at, we'll do the same, 2:10.
Thank you, Senator. Any other announcements before we adjourn today? Or I guess we'll recess? We'll recess, actually. So that, Senator, let me, not unfinished, we'll recess and come back and take up where we are. So we won't. All right, Chair, let's do a quorum call before we recess.
Mr. President?
Has everyone recorded their presence? If so, the clerk will take the call. With 47 members in the chamber and the quorum being present, Senate of Maryland remains in session. Chair recognizes the Majority Leader.
Thank you, Mr. President. I move that the Senate of Maryland stand in recess until later today, March 2nd at 6 p.m.
6 p.m. Without objection, so ordered.